Hello, everyone, and welcome to the April 2nd, 2015 Bank Solutions Group webinar series for upcoming changes to RESPA and Truth in Lending. I would like to welcome today's presenter, James DeFrance. James, thank you for joining us. I'm going to turn the presentation over to you. Everyone, please, if you have questions, you can enter those into the chat window, and we will address them at the close of the session. During the session, everyone will be in listen-only mode, but you can absolutely use that chat window for questions. James, again, thank you for joining us.
Well, thank you, Susan, and thank you, everybody, for listening in. Remember that we have this series the first week of every month, and we invite you to join the series. If you have any ideas or suggestions for webinars you'd like to hear, just let us know through our website. Today we're talking about upcoming changes to RESPA and TILA. RESPA being the Real Estate Settlement Procedures Act, TILA being the Truth in Lending Act, Reg Z. These changes have been talked about for a very long time, even though attention has been given to them now. Most recently, they've actually been in the works for well over 17 years. The reason for this is that both of these regulations do similar things when it comes to mortgages. The biggest difference between RESPA and Reg Z, that is TILA, the Truth in Lending Act, is that RESPA only applies to mortgages while the Truth in Lending Act applies to all consumer lending. But the basic purpose of both RESPA and TILA is the same, and that is to inform customers of the total cost of the money that they're borrowing. Now, RESPA and TILA have the same history as all consumer regulations. In fact, each and every one of them is well earned, and I say that because they're the result of either unethical or illegal behavior on the part of banks. For example, the Truth in Lending Act comes from the fact that there was a time when you got a loan, you'd have no idea how much you were actually going to have to pay back. This practice was rampant among soldiers who were coming back from World War II, and as a result, the Truth in Lending Act was born. As you see on the screen there, that is the preamble from Congress that explains why it was that the Truth in Lending Act was passed. The same can be said for RESPA. Once again, the idea here is that RESPA is supposed to make it easier for you to shop for a loan, and the way it does that is to make sure that all the charges and expenses and costs of a loan are listed and given to the customer actually before they select a loan. The idea is that you can go from one bank to the other and compare the cost of getting a home mortgage. This, by the way, is why the regulators are so insistent that they use their particular forms and not vary from those, because the idea is that the information should look the same from one bank to the next. So changes are coming. RESPA and TILA are going to be put together into one form, and there's a couple of things that this new rule does. Probably the two most notable things are you get rid of the GFE and the Truth in Lending statements, and those are going to be combined into a new form called the loan estimate. We will show you that loan estimate later on in this presentation. Now, the loan estimate is just like the GFE. It's due within 3 days of the receipt of a completed application. So many of these rules haven't really changed. It's just the form itself that has changed. The other big change is that the HUD 1 and the final Truth in Lending statement are done away with, and they're combined into a new form that's called the closing document. One significant change is that the closing document has to be delivered 3 days before the loan is consummated. And consummated in this case means that 3 days before the customer becomes liable to pay the loan back. All these rules hard start date of August 1st, 2015. So if you get an application on August 1st, the new rules apply. Just as a side note, there are some exempt loans. I'll talk a little bit about those, but for those loans that are exempt, You can still use the old GFE and HUD-1, or you can use the new forms. It's entirely up to the decision of your bank. Some of the other changes that are coming, several things are prevented. For example, here, imposing fees on a consumer before the consumer has received the loan estimate. No fees can be paid. No fees are liable until the loan estimate has been given and the borrower has given an intent to proceed. Under the rule, the borrower can give their intent to proceed in any way that is reasonable. They can tell you, they can go ahead and fill out the application. Anything like that is acceptable as intent to proceed. It doesn't have to be a formal letter or any sort of written document. Also prevented are doing any written estimates of the terms and costs of the loan unless you're going to tell the customer that these costs may change, that they're just an estimate. Finally, any sort of application documents, any sort of income documents cannot be requested until the loan estimate has been given. The way we interpret this is do the loan estimate first before you do anything else, any other part of the transaction, and you should be in pretty good shape. Here's an example of the new form, the loan estimate. I realize that it's somewhat hard to read, but this is just for discussion purposes. Generally, the creditor is responsible for ensuring that it delivers the loan estimate no later than the 3rd business day after receiving the consumer's application. If a charge paid or imposed on the consumer exceeds the amount originally disclosed on the loan estimate, it's not in good faith. So it's critically important that this loan estimate cover all of the costs that will be associated with the loan. So again, the way that you can tell whether or not this loan estimate is in good faith is if the customer has to pay more than that at the time of closing, then it's generally not considered in good faith. Here's an example then of the closing statement. Let's see, general information, the loan terms table, projected payments, costs at closing are all on this first page. So it's just a general description of how much it's going to cost and where the costs are going. The next few pages discuss the cost of the additional costs that are associated with third parties, such as pest inspection and all that sort of stuff. And all the same rules from RESPA still apply. In the event that the customer uses a vendor that the bank has listed on the loan estimate, then there's a 10% tolerance. If the customer uses a vendor that's not listed on the loan estimate, then there's no tolerance and the customer is left to pay that fee on their own. But the same rules apply as far as the no tolerance, 10% tolerance, and so forth. Nothing's changed there, simply the form that we're using. Again, there's the 3rd, 4th, and 5th pages of the closing statement. All right. Some other rules to be aware of, that there are some loans that are exempt. We talked a little bit about this earlier. It does not apply to, this new rule doesn't apply to HELOCs, reverse mortgages, mobile homes, and as you can see, dwelling that's not attached to property, so prefab housing. Remember though, you can still use this new form if you want to. Also the OGFE and HUD-1 will also do for any of these loans that are considered exempt. As far as retention of the documents, the loan estimate and the closing statement, 3 years for the loan estimate, 5 years for the closing statement. In the event that a loan is sold after it's closed, that closing statement has to be included in the loan sale package, and the purchasing organization has to keep that closing statement for the 5 years, so the remaining 5 years. So if the loan is sold, say, after the first year, the purchaser needs to keep that closing statement for the remaining 4 years. So in summary, August 1st is an absolute drop-dead start date. Remember that the loan estimate replaces the GFE and the truth in lending estimate. Remember that no charges or information should be made against the customer until the loan estimate is given. Good faith means that the borrower pays less than what's on the loan applicant, on the loan estimate, and all the other rules still apply. So everything that was still part of RESPA is still there. It's just a new form and a bit of a different procedure. And that's it. Are there any questions?
James, we did have two questions come in while you were on the session. And again, if anyone else has a question while we are live, please feel free to put that in the chat window, and we'll pass that on to James. The first question, was what training is being recommended by the compliance department for the customer-facing mortgage people who are working with clients?
Good question, and I think the training that I recommend is, of course, being up to date on RESPA to begin with, because many of the requirements of RESPA has not changed, but it's incredibly important for the customer-facing people to understand that loan estimate has to be accurate, and it has to be really the first piece of information that's exchanged between the bank and the customer. Really, nothing else should happen before that, and I think that's the one message I would want to leave with everyone.
Okay, perfect. And then the second question was, to your knowledge, are consumers aware of these issues? And if they are, has there been any response from the consumer community?
That's always funny. No. Generally, consumers are not aware, and that's unfortunately the case with many of these regulations. There have been extensive hearings held, opportunities to comment on this, and so that's part of why this whole process has been delayed. It was originally going to take place in 2014, but the process was delayed. By and large, despite the fact that consumers are generally unaware of this, I think if you look at the form, you'll see that it really is a good thing. It's an opportunity to get all of the information that's necessary in one place, and it really is easier to follow and easier to read, which is the goal of RESPA in particular, but RESPA and TILA in general.
That is perfect. Well, again, thank you so much for all who were able to attend today. We will have the session recorded and available for you on the BSG YouTube channel so that you can go back and review it or share it with colleagues at your organization. And again, as James mentioned earlier, please visit our website at banksolutionsgroup.com where new sessions are posted that you can log into the first Thursday of every month. Thank you again. James, thank you. And we will talk to you again this time next month. Bye-bye.